Alright, welcome back. So this is the moment you've all been waiting for, the standard of review. So the thing that we have been talking about all semester, the reasonableness of a decision, we now actually look at. And you'll recall we adopted a textbook which has a somewhat different approach. Usually the way administrative law works and is taught is that you start with the standard of review. And that makes sense somewhat because it's the thing that gets talked about most. It's the first question the court asks for, right? You have a bunch of issues usually, so you'll say there's a breach of procedural fairness. Now you know all this because you learned it first, right? But otherwise you went to breach of procedural fairness, there's a problem with jurisdiction, and there's a lot of problems with the substance of the decision, the reasoning that was made, which makes the decision unreasonable. The first thing the court asks is, which standard of review do we apply to each of these issues? And the court has to decide that before it looks at the issues, because that's the way the review works, right? The review process. You have to know how to review an issue before you can start reviewing it. And as you have learned so far, right, the nature of the issue will determine the nature of the standard of review. And the nature of the standard of review will determine, in significant part, the ultimate decision of the court, how much deference is owed, and that will often mean that the review process is conducted much differently. Usually you'd learn, again, the standard of review first, because it's talked about the most. However, we decided to look at it more systematically, more chronologically, right? What is an administrative decision to start with? Who is an administrative decision maker? Then how do they get their power, right? Their jurisdiction. By virtue of the Constitution, by virtue of a statute, which creates them and provides them specific powers. Then how do they conduct themselves? How do they exercise that power? And then eventually it has something to do with procedural fairness, procedure, how they hear the parties. Then they have to decide the substance of the issue before them. And all that happens before anyone ever says. And oftentimes, no one will ever say that a court needs to review that decision. Which is when, eventually, once you go to court, which we said you have a right to, we looked at how that happens, how you get to court, which part of the Constitution says you have a right to get to court. Why? How? And then the court, when it exercises that constitutional prerogative to review the administrative system, then, and only then, do you get to the thing that people learned first, which is the standard of review, which is how does the court look at it? And certainly so far, it might have felt that reasonableness was something you kind of understood. Because it is. It's not that hard to understand, right? It's essentially a mirror of deference. You want to not review the decision too much. So you allow for a bad decision to stand, even though it doesn't seem to be the best one, as long as it's not really bad, or bad for a really serious reason, like procedural fairness, or a big breach of procedural fairness. It's a mirror of deference and allows for a range of decisions. In contrast, correctness imposes a specific obligation to make a specific decision, and then if the court disagrees, it substitutes its decision. All that kind of makes sense intuitively. You probably understood that right week 2 or 3. That's good. As you'll find, right, not only do people teaching this assume you understand, the Supreme Court does as well. You'll see there's a pretty detailed discussion this week and the next few weeks of the term of the standard of review, of how you conduct review. But you'll see it's not that clear, right? Because it has to do again with all the things we saw. with which standard you pick for which issue, why and how, doesn't have a lot to say, the Supreme Court, about what reasonableness means or how you conduct that review. It has some to say, but not much, and you'll see it relies very much on that intuitive understanding, which is not always justified with specifics as to the underlying either concerns or ways in which you conduct that review. So, you have first a discussion of the nature of the relationship between the courts and the administrative system, something we talked about quite a bit, right? You have essentially three entities here. Usually you have three other entities, right? You have the legislative, the executive, and the judiciary. So you have the government, it's the executive, right? Then you have the legislative, which in Canada is merged, right? Justin Trudeau is the king of both. Nonetheless, it's not the same people. You have the executive, right? Justin Trudeau has ministers, but also lots of people in government who apply the law. And they're not the same people necessarily as those who vote on the law, the legislators. And then you have the judiciary, the courts, right, which apply the law. Three branches, right? Constitution, all that stuff you learned last year. In the administrative system, it's different because you have a delegation of executive power, could also be legislative power in some way, to the administrative system. And that is reviewed by the courts. But now you have a different interplay. You have the delegatee, the administrative entity, which is making rules or applying rules, right? And then you have the delegator, who has an intent. So the people who pass the law, delegating executive or legislative, right, rulemaking really, but legislative power to an administrative entity, have an intent. They have a reason for which they want to delegate that power. And then you have the courts. So the usual interplay of, right, the people pass laws and then the courts review that exercise, usually with checking whether it's charter compliant or whether it's within jurisdiction, but very limited grounds. Now you have the legislator, right, delegating some of that power with a specific intent, and often an intent for the courts not to intervene. So the courts have to deal with that, right, and exercise their constitutionally appointed role in a different way and in a way that's respectful of that intent, which often has to prevail. And that's how you end up with, right, the courts exercising a more limited role than they otherwise would through the standard of review we call reasonableness. And that's increased with the scope of government, right? We said there's limited things that you cannot subtract from judicial review because of sections, right, 91 and 92, and because of the constitutional role of the courts. And we said, if it's a power at confederation, right, that was quite a bit ago, you cannot subtract it from the purview of the superior courts. But then we said that that doesn't have much meaning today, because most things that are done by the government were not done by the government at confederation. That's because the scope and the role of the government has changed a great deal. The government's more interventionist, has a lot more of a role in our lives, right? There wasn't workers' safety protection, there wasn't a welfare state, there wasn't car accident benefits at confederation. All these things are developments of the government. That's why they can be delegated. And in fact, that's why they are delegated. That's why you have so many administrative agencies now making decisions and passing rules. That's because the role of government has expanded significantly, and there is a need to delegate some of that, right, to other entities to ensure that the government can do all the things that it wants to do. Okay, and as we said, right, the government can always evidence an intent to reduce the scope of the role of the courts, but can never remove it, because the courts have a constitutionally appointed role which cannot be fully, right, evacuated to review the decisions that are made by the administrative system. They can review them more deferentially. The government can put lots of steps in their way, internal appeal mechanisms, rules limiting the nature of the review being conducted. But at the end of the day, as we said, you always have a right to go to court, eventually, and to claim at least review upon a standard of reasonableness, which is much better than no review at all, because no review at all is constitutionally prohibited. Okay, then 443 and following, you have lots of discussion of things we talked about all semester. Privative clauses, right? The government tries to prevent as much review as it can by saying this decision is final without appeal. It's one way for the government to evidence an intent for the courts not to intervene, and the courts will respect that as much as they can. Same thing if you have a discretionary power. We said it's the nature of a discretionary power that it can be exercised for a lot of different reasons, and often not exercised at all or exercised for no reason at all, though not a bad reason, as we said. It's another way in which the government can evidence an intent for the courts not to intervene, and the courts will respect that as much as they can, right? Will respect that by intervening far less, but of course not by not intervening at all. And that's been changed in Vavilov in that there's a default presumption of reasonableness, as we said. So we'll write it down, but certainly you know that already, right? There's a default presumption that the standard of reasonableness applies. That wasn't the case before under the thing called Dunsmuir, right, which was the prior decisions we said, right? The whole thing about how you review administrative decisions had to be made up by the courts, right? So you have a statute, for example, the Car Accident Tribunal Act, right, which provides for the powers of the car tribunal, how these powers are exercised, blah, 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 right? That's one thing. That allows you to assess the nature, scope, and exercise of the power of the car tribunal. But, however, doesn't provide a general framework to assess administrative action. Doesn't create a standard of reasonableness and correctness, generally. These are not things that are provided for by statute or things that are provided for in the common law. The courts had to make it up. Right? The whole thing about reasonableness, correctness, that was made up by the courts. Before Vavilov, which we said is the 2019 decision where the Supreme Court renovated the standard of reviews, changed it somewhat significantly. Before that, you had another precedent called Dunsmuir, which had become, as we said, complicated and unworkable. And under that precedent, you had categories. You had things that fell under correctness review, things that fell under reasonableness review. That became complicated because it was as though the standards were equal, the categories weren't clear, people were getting correctness review too much, which defeated the intent of the legislator, were asking for correctness review even more of the time, which also defeated the intent of the legislator, and, right, it was as though both standards were equal because you had a list of things under both. Supreme Court simplifies that, and Vavilov says there's a default presumption of reasonableness review. So, by default, if you don't know, if it's a category that we haven't thought about, it is reasonableness review, period. Unless it's one of the exceptions, which are specifically enumerated, as we'll see there are 5, right? But beyond that, there's default presumption it's reasonableness, including for things that historically were subject to correctness review, such as jurisdiction, procedural fairness. These are all, at least notionally, subject to a presumption that the applicable standard is reasonableness review. Okay, so what that means is that there's a presumption of deference, essentially. There's a presumption that, regardless of the issue, the very fact that the government has delegated a power to the administrative system, that is evidence of an intent of the government for that power to be exercised and reviewed with deference from the courts, which was not the case earlier, and is a corollary of what I said, right? It's a corollary of why you have a presumption of reasonableness review to start with. Okay, page 448, you have the infamous exceptions, which we'll mention. Okay, so I'm at the bottom of page 448 says there's two principal reasons. As we'll see, they're actually declinated into more specific ones. So, okay, it says there's two. First one is essentially when you have legislative intent, but as we'll see, it's actually two specific things. So, presumption of reasonableness reviews. We said affects the deference, actually the whole thing's about deference. Reasonableness review, right, is about the courts allowing for more than one possible decision to be made, which is about, right, deference to the administrative system. So, the first, again, says there's two sub-issues within the first, three within the second, so the two are actually five. First one is, broadly, intent. You can rebut the presumption of reasonableness review with legislative intent, which makes sense because, as we said, legislative intent is what you started out with. It's the whole, right, overarching principle is respecting legislative intent, and that's why you have reasonableness review and a presumption of reasonableness review to start with. So you can rebut that presumption, get something else in reasonableness review with legislative intent. Makes sense. First, the statute. If the statute provides for a different standard, statute provides for correctness review, then, right, you'll rebut the presumption that reasonableness review applies. Second, a statutory right of appeal. Same underlying issue there of intent, right? If the government provides or does not provide for right of appeal, tries to shield a decision from the courts or do the opposite, it can evidence an intent, right? If it, say, provides for a right of appeal, can, before the courts, can evidence an intent, therefore, for the courts to be more interventionist, less deferential, the courts will respect that. Second category, which is three subcategories, is, and again, page 448, right, rule of law, which is when, right, essentially the underlying issue there is that the role of the courts within the democratic system mandates it. So regardless of the government's intent, we provide for less deferential, more interventionist review through correctness review because it's required. So you'll recall there were certain serious jurisdictional issues, right? Serious procedural fairness issues, and it doesn't matter what the government means because it's a constitutionally mandated issue or it's constitutionally mandated role of the courts to ensure that, right, big bad things aren't done under the cover of deference, right? You don't have serious breaches of procedural fairness and serious issues involving the parties' rights being decided that way. So three subcategories, as I said. which are mentioned at page 448. Okay, so first, constitutional questions. As we said, when an administrative decision maker decides a constitutional issue, and we saw all the framework for that, we said they don't even have a right to decide a constitutional issue all the time. By default, they don't, unless the statute has implied power for them to do that. We saw that many weeks back, right? When they do have the power to review constitutional question, we said, there's a different remedy that applies. The decision maker will not invalidate the constitutional provision, which would have general applicability on all litigants, future ones, right, as a court would, because it can't. It has to decide not to apply the specific provision, which will not have a direct impact on other cases. In conducting a constitutional assessment, so saying, for example, something does not meet Section 7 of the Charter. Charter is in the Constitution. Breach Charter is a constitutional question. Upon judicial review, there's no deference for that. Correctness. Court reviews it, decides whether it's right or not, whether it's the decision a court would have made or not. If it's not, court owes no deference. Then, questions of central importance to the legal system as a whole. You'll recall that's the one thing that people will always claim, because it's the broadest one and the more subjective one. Essentially what it means is described in the chapter is two things. First, it's a general issue. So the whole phrase there is a question of law of central importance to the legal system as a whole. So the rest of it is important, right? A question of law of central importance to the legal system as a whole. So two parts there. First, it's general, the legal system as a whole. So a question of law of importance to the legal system as a whole. So has an impact, essentially, on more than the instant case. If the decision maker decides something, although they don't create case law, they will create case law, and it will have a big impact. As was the case, that's why it's also the rule of law for a constitutional question. Right? Even though they cannot invalidate a provision for everyone, it has an impact, of course, because they just said a law doesn't respect the Charter. People take notice, even if they don't have to apply that decision. It's really serious and has the potential to impact future cases. And therefore, the administrative decision maker, which is, not a judge, not all as qualified as a judge, not independent as a judge, right? It's taken upon themselves a serious issue of constitutional importance, of the constitutionally mandated role of the courts. And therefore, it's reviewed less deferentially. Central importance to the legal system as a whole, same thing. An issue that has a broader impact, which is not a constitutional question, on more than the instant case. That's the whole thing. And it's a big issue, an important issue. That's the central importance part. Fifth, the jurisdictional boundaries between administrative decision maker. And that's extremely precise. It's not jurisdiction. But recall we said there are jurisdictional issues which are subject to correctness review. Here they are. There's other ones, but these are the ones where the presumption is rebutted. By default, therefore, the presumption of reasonableness review does apply to everything, including, at least notionally, procedural fairness and jurisdiction. Where it doesn't apply is the jurisdictional boundaries between decision makers. That's very, very specific. So, in deciding not whether an administrative decision maker has jurisdiction, so whether the statute provides them the power that they are trying to exercise, not that. The jurisdictional boundary. So, whether they have that power or another decision maker, by virtue of another statute, has that power. And that is a jurisdictional issue, of course, and it's one where there's no deference because there's a potential for conflicting decisions, and again, that's a rule of law problem, right? There's a potential for conflicting decisions, for decisions to be made by two administrative decision makers on a general issue underlying a legislative scheme, for example, welfare, right, which is inconsistent. And there's also a risk for someone not to know who they're subject to or for concurrent jurisdiction to apply where it otherwise wouldn't, and that's why you have greater intervention. So, two general categories. The intent, legislative intent, can rebut the presumption, default presumption of reasonableness review, and the rule of law, and they are declinated into actually a total of 5, specifically provided for exception to the presumption of reasonableness review. And that's it. They're the 5. No more. Supreme Court says we can find some more in the future because, we're not that convinced that we're so smart we figured everything out, but it's going to have to be just as serious and exceptional. And it hasn't happened so far in 3 years, 2 years, 2.5 years. So, and it's not likely to. And the court was careful for 49 or so, right, to frame it that way. And it's helpful for you to actually read Vavilov this week and go through it. Frankly, I think it's summarized with the numbering more clearly than the actual decision, but it's helpful for you to follow the actual decision, not just have, the author categorizing it for you. So, as we said, potential for additional categories, very hard, hasn't happened so far, and that's because the court was careful not to have Dunsmuir, not to have the issue with the old standard review framework, that it got more complex than it should have. And by providing for a default presumption of reasonableness review, the court's simplifying things. There aren't buckets now. This is by default what you do. And these are the 5, not 10, not 20, just 5, and that's it. And that was clearly the intent of the court, even though it notionally left open the possibility that some would be added in the future. Okay, we'll see them in a bit more detail as it becomes important. One, I don't have anything to add on. Second, statutory right of appeal. What does that mean? First, it's an appeal of any kind. So, it can be a right of appeal, as of right, or with leave. So, it means what it says. As of right means you have a right to appeal. With leave means you have to ask for permission. So, for example, in our system, you don't have a right to appeal to the Supreme Court, unless it's a very weird criminal law case where the Superior Court and the Court of Appeal disagree on a question of law. Unless it's that. You don't have a right to show up at the Supreme Court. You have to ask for permission to go there. And that is what we call leave. Both of these, in the statute, count as a right of appeal that would allow for less deferential review to apply. And it has to be not a right to judicial review, which can be specifically enumerated, and you see that, for example, in the Federal Courts Act, actually most prominently in the Federal Courts Act, where a right to judicial review is provided for by statute. That's, of course, not appeal. It's just a regular right to judicial review, which is circumscribed or provided for in the same way as general administrative law principles under reasonableness review. Okay, then you have the standard that does apply, page 451, when you do have a right, it's less deferential, and it's reviewed upon essentially the same standard as a court of appeal, and you have the details there. Then, constitutional questions, as we said, can be anything under the Constitution, page 452, section 35, section 91, 92, the Charter, these are all constitutional issues, and they're all underpinned by the policy concern that we mentioned earlier. It does not apply, though, it's something I almost forgot to mention, to the Dore case, which we saw earlier, which was the guy who said something bad about a judge in a letter. And then the bar got involved, and complex administrative thing about whether the bar had the power to do what they did. So that was about charter balancing. We saw that. We saw charter values, we said. If you have a discretionary power or some other kind of power, it has to be exercised compliant with the charter. So even though you're not violating charter rights yet, or not violating charter rights at all, you have to exercise, for example, your discretion, and you can go back to that, right? We saw that case specifically. So you have to exercise that in a way that's consistent with charter values. That is not a constitutional question. We saw that actually under that header. But it's not a constitutional question because it doesn't invoke the Constitution directly. It's not a charter right, it's a charter value, and that's why, right, it's not reviewed less deferentially, because a charter right has yet to be specifically engaged. Okay, central importance to the legal system as a whole, page 453. You have what I said. It's about the broader impact and the importance of the question. So, a result of their impact on the administration of justice as a whole, that's what I said earlier, require uniform and consistent answers. So you don't want them to be decided unilaterally by an administrative decision maker, and you don't want them to be decided definitively or inconsistently by an administrative decision maker. You have some example 453 and 4, which are somewhat informative. You should read them, of specific issues that do or don't constitute issues of central importance to the legal system as a whole. And as you'll see, essentially, it's pleaded a lot of the time, but it doesn't apply all that often. Right? Somewhat more often than, say, constitutional questions, but not that much more often than constitutional questions. Okay, then the rationale I mentioned for jurisdictional boundaries, that's page 454 and following. I won't repeat it, right? Essentially, it's because there's a potential for conflicting decisions or for a person to be subjected to, right, either two tribunals concurrently when that wasn't the intent, or neither, right, or one when it should be the other. Okay, there is a sixth potential category, which we alluded to all term, page 456 and following. The author says he thinks that's correct. I think that's correct. We don't know. It appears that you can rebut that presumption with big problems, and often big problems of natural justice, procedural fairness. So procedural fairness or big jurisdictional issues. You might be able to get correctness review, but it's not clear. I think it is the case, but right, as we said all term, it's not clear per the Supreme Court's framework. And that's especially true because you have the Baker stuff that comes in. Because the court says, right, on top of that, Baker still applies by virtue of Vavilov, even though it significantly predates it. And Baker says, right, we don't know. It says procedural fairness, not really the standard of review. Not correctness or reasonableness, neither, both, we don't really know. It's the eminently variable standard, where you look at the stringency of the procedural fairness protections, which will apply along a spectrum depending on the seriousness of the decision and all the other factors we saw, and then you assess whether that was respected, and that doesn't specifically invoke either correctness or reasonableness review, and in fact doesn't tell you which standard it is or whether it's one of them or not. Okay, page 459 and following, you have a discussion of reasonableness review. As I said again, the Supreme Court, as I did, and as the courts do, assume you know. Right? They assume that you know what it means. It means deference. It means there's more than one potential alternative. You'll see it doesn't get all that much more specific than that. Nonetheless, there's some important principles in Vavilov, which again you should read. which are stressed. Page 460, I'll mention them specifically. Some of these passages are already famous. So, first, when there are reasons for the decision. Again, don't have to be, might be required by virtue of procedural fairness indirectly, but by default, no need for reasons. You can piece it out with a one sentence that says you don't get your license because you're blind. You can piece it out from the record. What you do always have, as we said last week, under procedural fairness, is a right to know why. So if with the reasons or the sentence or the record, if with all of that you can't figure out why the decision was made, it's not valid under procedural fairness. Once you can figure it out, you're fine. Right? And then you assess whether it's reasonable or not. So you might be mandated further reasons, as we said under procedural fairness, generally if it's a really important decision. So, principle 460, when there are reasons, you put the reasons first. Before you start relooking at all the evidence, you're trying to be as little interventionist as you can, so you look at the reasons and put the reasons first. You focus on, quote, justification, transparency, and intelligibility. It's another important principle in Vavilov, right? So you focus on whether the reasons for the decision are clear, essentially, and justify the outcome. It's justification, transparency, and intelligibility. Fall within a range of outcomes defensible given the facts and the law, right? That's what we said. And there has to be a relationship between the reasons and the outcome. So you cannot justify a good outcome with some other reasons than the ones that were provided. The reasons need to justify the outcome. You can't retroactively make it up. And in contrast, right, you can't save a proper outcome or invalidate a bad outcome for a reason that's not directly related to the reasons that were provided for that outcome. That's again at page 460 at the bottom. Okay, so we said there has to be some respect of what we call the factual and legal constraints bearing upon the administrative decision maker. These are some of the magic words, and Vavilov will see more specifically what they mean. 462 is something we said earlier in the term, doesn't mean it will look like a court. It might not, and that's true of everything. It's true of the procedure under procedural fairness. It might take away lots of your right, not really look like a court because you don't have a right to be heard in a lot of ways. It can be true of the decision maker. They oftentimes will be a non-lawyer who doesn't know the law and doesn't apply the law. They might cite weird stuff. They might cite it weirdly. And all of that, the Supreme Court says in Vavilov, enriches the decision-making process. Not only is it allowed, even though it's not legal, yet bears upon legal rights, privileges, and interests, right? As the team from last week mentioned. Nonetheless, it's decided that way, and that not only is it allowed, it enriches the decision-making system. Okay, and we'll pause there, erase the board, and then look at specifically the factual and legal constraints bearing upon a decision maker.